Welcome, everyone. My name is Camden Hutchison. I am the director of the Center for Business Law, and I will be introducing this evening's event entitled The Global Minimum Tax, Illusion, Intrigue, and Canada's Choice with Professor Wei Cui. Thank you, everyone who's joining us online and everyone who made it here in person, including my parents, who who flew to Canada to attend this talk. That's how renowned Professor Cui is. This event is being presented by the Center for Business Law and is also co-sponsored by the UBC Tax Law Club. So thank you to them for their help. I also just want to mention that there is a reception following this event. However, the reception will be upstairs in the Terrace Lounge. So please join us on the fourth floor afterwards for that. So allow me to introduce tonight's speaker. Professor Wei Cui's research spans a wide range of topics in tax law and policy. His current research interests include international taxation and tax and subsidy policies designed to combat climate change and to support innovation. He is the author of The Administrative Foundations of the Chinese Fiscal State and Value-Added Tax, A Comparative Approach, both published by Cambridge University Press. He has held visiting appointments at the NYU, Michigan, Columbia, and Melbourne Law Schools, among other institutions. Before becoming a full-time academic, Professor Cui practiced tax law for over 10 years with leading global firms in both New York and Beijing. He received a BA from Harvard College and a JD degree from the Yale Law School. Professor Cui will be speaking on the global minimum tax, and so without further ado, I will let him take it away.
Okay, thank you so much, Camden. I want to thank the CBL team for putting this event together, and thank you all for coming, seriously. So I'm glad that you mentioned the reception. This is sort of the excuse for that reception afterwards, right? But so originally when I proposed the talk, I proposed the talk, I didn't propose the reception. So my motivation was that there's this pretty unusual federal legislation that is politically important, but it really hasn't received a lot of public discussion. So I believe that members of the public, including journalists, are still probably confused or not really following what's going on. So I thought I would do some public service, give a talk, record it, and then contribute that way. But then I found out that it comes at the end of the semester with food and beverage served afterwards. Doesn't really matter whether I do public education anymore. Anyway, thank you again for coming. So my talk is about the global minimum tax. Can I just start by asking how many of you have heard about this thing before? Okay, so I would say like barely a half, and so this is a relatively new topic for some of you. That's great. So I will start. Okay, it's moving now. All right, great. So Canada has proposed to implement something called the global minimum tax starting January 1st, 2024. So this is draft legislation called the Global Minimum Tax Act. It still awaits royal assent, but once it receives royal assent, it will have already applied. It's law, you can say almost in force now. So the draft law is heavily based on existing guidance from the OECD and will incorporate future OECD guidance. Now, have you all heard of the Organization for Economic Cooperation and Development? Okay, great, yeah, but it's okay if you haven't. We actually can leave for discussion what this thing is, the OECD, and how does it get to make rules for the rest of the world. But the OECD has drafted this law sort of for us in Canada, and that's sort of the big story. The big story is that what we're adopting in Canada supposedly will be adopted by many other countries as well. This is why we follow the OECD. Everyone is adopting the same thing, okay? And so what is the tax about? Here's an elevator pitch, and this is a pitch that's perfected by some of the world's most elite journalists and used by our governments and others. The tax will ensure that large multinational enterprises pay a minimum of 15% of tax on their profits somewhere. And the reason for having this agreement is supposedly global average corporate tax rates have been declining in the past half century because of international tax competition. Countries reached a historical agreement in 2021 to collectively adopt the global minimum tax, which is also termed Pillar 2 of the OECD's proposal, to limit tax competition. You had tax competition, now we're limiting tax competition. The whole world is limiting tax competition. Therefore, we're solving a collective action problem. This is a loss for multinational enterprises. They will be paying more tax, but supposedly it's a win for workers, the middle class, and their political champions. So this is a pretty good elevator pitch. When Camden we talked about my talk, I tried to give my pitch of my story. I couldn't do it. This is very good work. And so I hope this sounds interesting. But also there's a side of me that suspects that you think it's interesting because you have low expectations for tax. There are not that many great stories. I also suspect that journalists tell the story because they think this is the best story they can tell about tax. Otherwise, no one will read about tax. Okay. So what I'm going to argue in the talk today is that there are better stories to be told about tax, just in connection with the global minimum tax. So I hope you give me the benefit of the doubt. I want to explain that the story of the global minimum tax is filled with illusions and intrigues. Nothing is as it seems. Okay. So I'm going to be explaining 3 illusions implicit in this narrative that I just showed you. There's the illusion of agreement, there's the illusion of enforcement, and the illusion of a problem to be solved. These illusions are intrigues at the same time because they are perpetuated by people who know that they're untrue. There's also a separate intrigue. I will show you that the global minimum tax surprisingly involves an offer that low tax countries, sometimes also called tax havens, cannot refuse. Okay. And so it's going to be pretty surprising, I think, to many of you. Now, to make sure that I'm not carried away too much by my story, you don't come here just to hear a crazy story in Wei's head. I'm going to talk about policy implications for Canada towards the end. But the policy implications will follow from the story of illusions and intrigues that I will give you. So that's the outline for the talk. I'm going to explain 3 illusions, intriguing because they're knowingly perpetuated, 1 additional intrigue, and then Canada's choice. Okay, first, the agreement, the illusion of agreement. What is the global agreement that the world entered into in 2021? The way the world experienced these agreements is that the OECD, which is an organization with headquarters in Paris, issued several online press releases, which were picked up by major news outlets. So on the slide, you can see one example of a New York article by the New York Times about this development, and you know, many of you will have seen some version of this before. Now, what about the press release themselves? They look like this thing on the right. Okay, so this is the OECD website, but you know, this is how websites work. There's nothing sinister about this. You just can't find the original things easily. I want to take note, however, that for me, this is sort of a symbol of how the chosen medium in which the story of global tax cooperation is told, namely press releases, lends themselves easily to revision and deletion. So in some of these press releases, there's actually a document that you can locate, that you can always look at. And here's one of the central documents. This is a statement in October 8th, 2021, from the OECD. At the top, the highlighted language says, this document sets out the statement which has been discussed in the OECD G20 Inclusive Framework on BEPS. 136 member jurisdictions have agreed to it as of October 8th, 2021. It is noted that not all inclusive framework members have joined as of today. So this is what we find for October 8th. It's a statement. This statement refers to an agreement. The agreement is not documented in any way except for in this format. There are no signatures, for example. Apparently, countries can explicitly say no to the statement. Some did, but there was no indication of what the procedure of agreement or dissent was. So you may ask, what is the status of this statement? I think the most obvious analogy is to communiques issued by informal international bodies. And so the G7 would issue a statement, the G20 would issue a statement. Those are heavily worked political statements by heads of state. So to evaluate communiques, we should ask, who are the people participating in this conference? Who are the people in what's called the inclusive framework that they're negotiating communiques? The answer is that for the majority of the countries referred to here, the participants are low or mid-level bureaucrats in tax or finance agencies, participating a lot of times by Zoom, and some of them are going to Paris. This raises the question, do they have mandates to negotiate a communique facing the world? This question, I think, is a reasonable question to ask. I think the factual answer in many cases is no. But what should be clear from this is that there's no legally binding obligation created. This is all that we have in terms of what people agreed on. People agreed on a statement, and that agreement itself has to be bracketed because we don't have any procedure or documentation. Why is this important? There are two basic reasons why it's important. First, when any country deliberates whether to adopt the global minimum tax, which is what Canada had to go through, they need to predict what other countries will do. This will become clearer later. So many have argued that, what do other countries do? Well, they have agreed to implement the tax, therefore we will do things accordingly. So this narrative of agreement is going to bear on real decisions, right? And so that's why we need to ask, what is the nature of the agreement? Second, in the last 2 years, some scholars have argued that the global minimum tax is in conflict with countries' existing legal obligations. And I will show you some of those arguments. Some, but not all of them, are good arguments. But there's definitely a bad counter argument. Some defenders of Pillar 2 actually claim that by issuing the communique, countries have already written a blank check to rewrite international law. And if you look at what the agreement is, I think obviously that cannot be the case. Okay. So there's a second interesting aspect of the October 2021 statement. It is drafted in such a way, it actually may not be possible not to agree with it. Okay. And this is because the global minimum tax is said to represent a common approach. And this is how it's defined in the OECD statement. The member countries who supposedly agreed with the statement are not required to adopt the global rules. This is the reference to the global minimum tax, Pillar 2. But if they choose to do so, they will implement and administer the rules in a way that is consistent with the outcomes provided for under Pillar 2, including in light of model rules and guidance agreed to by the inclusive framework. And they accept the application of the global rules applied by other inclusive framework members, including agreement as to rule order and the application of any agreed safe harbors. So this begins to look a little like legal language, but let's parse what it says. What does it mean to adopt the global rules? I can tell you, as of April 2024, we don't really know. For one, if a country adopts just one part of the rules, but not the entire set of rules, which has different components, does that count as adoption? It seems so far that people are willing to count that as adoption. Okay. And what if you adopt rules that differ from the guidance issued by the OECD, which is what is referred to here? Interestingly, that has been made almost necessary because the OECD's model rules and guidance have been gradually coming out and they have been changing. Okay, and so 2 months after October 2021, the Pillar 2 model rules introduced two core ideas that differed substantially from prior OECD descriptions of the tax and surprised many observers. Subsequent guidance is also generally regarded as introducing entirely new elements. So unless one says, we're going to do whatever the OECD drafts in the future, which, by the way, is what we're proposing to do in Canada. The GMTA actually says we will implement whatever OECD writes in the future. Unless you do that, we don't really know whether we're adopting the OECD rules. Okay, but I think it's, forget about all that detail. It's not hard to see that this statement, the first bullet point, is actually sort of empty. Because if you adopt a rule that's not consistent with the outcome provided by Pillar 2, you're just not adopting the globe rules. And so what constraint is actually put on by this first bullet point? There may be no constraint. Okay. This leads to the question, what does it mean for countries to accept the application of the globe rules by other countries? Here, again, the statement is empty. Either the globe rules violate or inconsistent with some kind of existing legal obligation or not. If there isn't any conflict, why do other countries have to indicate their acceptance? Right? There's nothing to give permission to. But if it does, is it really plausible that by signing a communique, so many countries have completely waived existing legal obligations that other countries had to each other? That seems to be completely unlikely. Okay, and so this is what countries agree to. And so you think, okay, maybe if this says nothing, then it's okay for low-level bureaucrats to say okay to this because it imposes no obligations. Now, even so, this is the striking thing, even though it seems that it's impossible not to agree, in fact, many countries have opted out of the OECD agreements. In November 2022, the United Nations General Assembly approved a resolution on global tax cooperation and proposed to start intergovernmental discussions in New York at the UN headquarters on ways to strengthen international tax cooperation. This resolution was proposed and objected to by the United States, Canada, and others, precisely because it was premised on the idea that the OECD was an inadequate forum for countries to reach agreements about international taxation. And in November 2023, there was yet another General Assembly vote declaring that efforts in international tax cooperation should be universal in approach and scope and fully consider the different needs and capacities of all states, in particular developing countries and countries in special situations. This was an explicit rebuke of the OECD arrangement, and you can see this in the pattern of votes in November 2023, where 125 countries, including all African countries, basically the global south, voted in favor. 48 countries, including Canada, and most global north countries voted against with 9 abstentions. This is very strong international disagreement. Okay, so have any of you heard of these UN resolutions? One of you, okay. Most of you haven't, okay. Good. So I think this is, to me, this has always been remarkable. If you haven't, it's not surprising because our press doesn't cover this, okay? So what I want to emphasize is that it's not the fact of serious disagreement among countries, it is that the semblance of agreement is the product of our media. If the OECD issues press releases alleging an international agreement, our news press will report a groundbreaking international agreement because it fits the narrative of our major newspapers. If the United Nations adopts a legally binding resolution on the same topic, our media may not just cover it, may just not cover it because it doesn't fit our preconceived narratives. And so in the boring world of tax, we have been witnessing something. I grew up in the 1990s when O.J. Simpson was on trial. There's this movie called Manufacturing Consent based on a book by Noam Chomsky. And that's what's been happening in the boring world of tax. Okay, now I move to the illusion of enforcement. So far, I have not told you much about how the global minimum tax works. This is because if any individual country adopted some components of the tax, it will not be that interesting. The whole tax is designed to create an interlocking mechanism for different countries collectively to subject multinational profits to a minimum tax. This is why we need to start by talking about whether there was an international agreement. Now that you know that any country can defect from the so-called agreement, many may already have, and now that you know that any country that enacts the global minimum tax, since there's no legal obligation, they can even repeal the legislation. There's the question, what gives momentum to this adoption across the world? A key narrative is that if enough governments adopt the tax, other governments, to protect their own self-interest, may have no choice but to adopt the tax. Okay, so for example, the United States is currently considering adoption of the tax. Some are for, some are against. One argument for adoption is that countries like Canada have already adopted, and therefore the US somehow loses out if it doesn't adopt. By the way, the Republican response in the United States to this has been, how dare you, Canada and Europe, to blackmail us and force us to adopt a tax that we don't adopt. There's a lot of political drama, okay? It turns out, though, this story that has created real political drama about enforcement of the global agreement is an illusion. And so I'm going to spend a little bit of time explaining this. I had to write a paper about this to sort out other people's confusions. I'm just going to give you the gist of the analysis. So this is slightly academic. And what's worse, I have to talk about something called the UTPR, the undertaxed profit rule. And the notorious thing about international taxation is that specialists in this field use acronyms without restraint. Okay, and so I have to avoid doing that. So I'm going to call this tax, the UTPR, the hot dog stand tax. Okay, and so this is how I get to call it that. Now, suppose, just imagine now that a Canadian multinational has a subsidiary in Singapore, a low tax jurisdiction, a lot of undertaxed profit there. It also has subsidiaries in the US and Canada that are subject to low effective taxation because governments give out subsidies, tax incentives, tax holidays of all kinds, right? So this kind of low tax profit earned by Canadian multinational subsidiaries are in the tens of millions. There are traditionally two ways of increasing that tax more. The first one is for the countries where the subsidiaries operate, such as Singapore, US, and Canada, to raise the taxes applicable to the subsidiaries. That's number one. Number two, traditionally, the country of the multinational's parent company can impose a tax on the parent company on their foreign profits, regardless of whether the profits have been distributed. Okay, that's another way to make sure that wherever you're moving the funds around, we're taxing you at a higher tax rate. Those are the two traditional ways of raising taxes from NEs. The UTPR, which is, I will explain, it's called the hot dog stand tax, introduces a third approach. This is what it does, okay? As long as any country hosts a subsidiary of a multinational, that country can impose a tax with respect to the low tax profit of the multinational anywhere. Okay, that is the country doesn't have to be the country where the profit is earned or where the parent company is located. It also doesn't matter if the low tax profit elsewhere has no relation to the country threatening to impose the tax. Okay, so this is why I call it a hot stand tax. Now imagine a Canadian multinational has operations in Canada, in the US, in Singapore, and it has an operation in South Korea, and that operation is a hot dog stand. Okay, And South Korea we imagine here to be adopting the under-tax profit rule, the UTPR. In reality, South Korea was one of the first countries that announced the adoption of the UTPR, surprising everyone, and then it backed off. It's actually going to wait for other people to adopt the UTPR. Now, South Korea adopted this rule that I told you about. The Canadian multinational has low tax profits elsewhere, we can see here. These other countries, Canada and the host countries of the low tax subsidiaries, don't rate their taxes to the minimum. In that case, the conditions are satisfied, so South Korea to impose a tax. What is the tax? There are two possibilities. One is the South Korea will collect as much tax from the hot dog stand as it can. Okay, that basically means confiscating the hot dog stand because there are tens of millions of profit elsewhere. Okay. Well, okay, you can do that. The other possibility is South Korea will just tax the tens of millions of profits that the Canadian multinational has elsewhere. It doesn't just tax the hot dog stand. Okay. The second possibility should seem astounding. Okay, it implies that a country that's actually worth very little to the multinational because it only has a hot dog stand there will collect so much tax because profit is earned elsewhere. So this idea has excited the most debate about this tax, the UTPR. Many tax experts have argued that it is interpreted to allow the second possibility violates international law or even moral principles. So I think it is pretty remarkable either way. And so if international law, I wonder if international law is not violated, if a country can confiscate the hot dog stand just because it doesn't like the laws of other countries hosting multinationals and allowing for low tax profits. In any case, this is where the current debate stands. The OECD won't say which is the correct interpretation of the tax. And second, the OECD also won't say whether interpreted to allow South Korea to tax more than the hot dog stand, the UTPR is compatible with international law. Okay, you can see how maintaining this ambiguity enhances the idea of enforcement, because on the second interpretation, any country can tax multinationals' profits anywhere. This will get other countries more concerned. It triggers action more easily. If it's instead just confiscating a hot dog stand, maybe a lot of countries will be indifferent. Okay. But there's a more important problem. Why doesn't the multinational simply leave South Korea if it has only a hot dog stand there? Right? This is pretty interesting. And then if it leaves, it doesn't matter which interpretation of the tax you apply. The multinational won't be there. There's nothing to tax. Okay. So I hope that question makes sense. It's a very simple question. It's a simple question that tax professionals around the world haven't been able to answer. Okay. There are two possibilities. One answer is, well, other countries have also agreed to impose the hot dog stand tax. Therefore, there's no place for you to go. This is where I draw, multiple hot dog stands. Okay. I don't know how convincing that answer is to you. To me, it's pretty obviously deficient because in order to sustain the illusion of enforcement, you are basically maintaining that the tax is already enforced. Other countries are adopting this tax. Okay, so you rely on an illusion of enforcement or an illusion of agreement in order to basically answer a basic question about how is the tax enforced. Another reply is that the world's most powerful countries will impose the hot dog stand tax or the UTPR. The multinationals cannot afford to leave these countries because they make so much profit there. The UTPR countries host not hot dog stands, they offer piles of gold. Okay, so this is the complication, and so I don't want us to spend too much time on this. But what does this mean to say that there are powerful countries imposing the UTPR and therefore the rest of us have to adopt the global minimum tax? Now, forget for now about all the powerful countries that haven't imposed the UTPR, which is basically all of them. Let's think about a couple of countries in Europe, like Germany and France, which promised to introduce the UTPR in 2025. If you assume that the multinationals have piles of gold in Germany and France, you assume that Germany and France have not taxed away the multinational profit yet, right? Okay, and so that's why they can impose an additional tax on multinational profit under this rule. So the UTPR basically would have Germany and France saying, we have all these profits from foreign multinationals that we're not taxing to the limit, but we will tax it to the limit. If you don't tax the multinational profit from your jurisdiction, we're going to force you to tax the profit in your jurisdiction, and then we're going to remove the UTPR and leave all that multinational profit, the piles of gold, again, untaxed in Germany and France. So that's pretty strange, and you can imagine other countries would say, that's pretty strange. You're punishing us for doing exactly what you do, which is leaving multinational profit untaxed. Okay, that's sort of weird. There are other ways of seeing how this is weird. You can imagine, for example, if the low tax jurisdiction is country Z in this chart, which has a hot dog stand, the country Z is not going to impose more of a tax on the hot dog stand because the multinationals would leave regardless of what happens elsewhere. Okay, and so it's not really credibly threatened by South Korea threatening or Germany and France threatening to adopt the UTPR. Okay, so this may be a little confusing. It's because this is a very confusing area. And so that's why I had to write a paper about this. Let's move on to something more straightforward. Okay, at this point, you might be puzzled. Wei, why are you poo-pooing this great story of global tax cooperation to tax big multinationals at the beginning? What are you getting at? What are your political sympathies? Okay, I think that's completely fair. I'm going to answer the question in 2 steps, and I'm going to hurry because I want to leave time for questions. The first step in the answer is that the feel-good story actually involves a genuine intellectual illusion. And I would start asking you, who do you think most want us to believe in international tax competition? Who is most interested in pitching the story of international tax competition? I can tell you, having followed tax policy for 20 years, the answer is multinationals themselves. Okay, they want us to tell that international tax competition is fierce so as to persuade governments to lower or at least not to raise taxes. Okay, so the question we should be asking, if we're not tax advisors or the business themselves, our question is, should we believe them? Or should we distrust claims about international tax competition that might just be self-serving rhetoric for the business lobby? Okay. Alternatively, I can ask as a scholar, is there a truth of the matter about the severity of international tax competition? In reality, the evidence for international tax competition is very flimsy. Okay. Usually you just get one thing, which is showing that the corporate tax rates in countries across the world have been coming down since the 1970s. Continuous decline. Okay. That is not evidence for international tax competition at all. A lot of things come down. The usage rate for fax machines have been coming down. The usage rate for video cassettes, for whatever appliances you have in mind, have been coming down, okay? Countries have not been competing to get rid of fax machines, video cassettes, typewriters, and so on, okay? And so when you see rates coming down, that is not evidence for tax competition at all, okay? You have to do something to understand what tax competition is. We need better evidence. And so I tell you, economic theory predicts and rigorous empirical evidence is more consistent with the view that there really isn't much international tax competition. Okay, this may seem very surprising to many of you, to most of you. I hope that you are surprised enough to check out a working paper of mine called The Mirage of Mobile Capital, where I explain the evidence and the theory pointing against the existence of international tax competition. Today, what I want to do is to highlight the consequence of this research conclusion. Suppose that we stop and think maybe there's not a lot of international tax competition. Then, if international tax competition is a fiction, global action to stop international tax competition is also based on fiction. It involves a different exercise than we normally think. Well, what does that mean? What do I mean by that? If I tell you that all that has happened is that multinationals claim, contrary to reality, that there's fierce international tax competition, and therefore tax rates have to be lowered. And now governments around the world say, we're implementing the global minimum tax, and we've stopped international tax competition. So you can't ask us for low tax rates anymore. Okay. So what is our collective action problem? Stopping international tax competition, or having something to say collectively back to multinationals, the business lobby, about something that we shouldn't believe in the first place? I would say that if it's the latter, if international tax competition is fictional, or having something to say to businesses about this lobby, saying that we will stop international tax competition, that is really not solving a collective action problem. Okay, that's why this research conclusion is important. Now, the second part of my answer to the question, why are you poo-pooing this feel-good story, is that not only is the global minimum tax aiming to solve a non-existent problem, it also does it in a perverse way. So this is what's at the heart of the bargain of Pillar 2. Many countries from which multinationals originate, including Canada, previously have taxed their multinationals' firm profits lightly. And so you can say that that's bad. We're giving subsidies to our corporations. You can say that. So we can debate about that. But what Pillar 2 does is to invite these countries from which multinationals originate to increase the tax on such profits by applying an extra tax on the ultimate parent companies. This is something called the income inclusion rule in Pillar 2. But simultaneously, it invites the low tax countries where such profits are currently booked, such as Ireland, Switzerland, Singapore, and Hong Kong, to also tax the same profit at 15% through something called the qualified domestic minimum top-up tax. See, all of these things I want to spare you of. So the idea is, if these low tax countries tax the same profit at the amount of the minimum tax, countries like Canada would no longer apply the extra tax on the parent companies. What does this mean? Okay, you have to think through what this means. Imagine government officials from the G7 countries sitting down with officials from Ireland, Switzerland, Singapore, and Hong Kong. The officials from the large economies say to the officials of the low tax countries, we large economies have a problem. We've been taxing our multinational corporations too little. Finally, the OECD has helped us figure out a solution. The solution is that you, low tax small economies, you need to tax our multinationals more. Okay. If you tax our multinationals more, they won't shift so much profit to you, and we won't feel too much pressure to engage in tax competition. Now, if your fear is that by increasing your taxes, you will drive multinationals away, we will help you. We will adopt something called the income inclusion rule, which is to say, we're going to tax our multinationals anyway, wherever they earn the profit. So they can't get away with no tax wherever they go. But since we're doing this, now you can tax that profit. And if you tax that profit, countries like Canada, we will give you a credit. We'll make sure that you don't lose from imposing the tax. How do the low tax countries respond? You can imagine there's a lot of confusion. You can imagine them thinking in their head, we didn't know this, but these large countries must really hate profit shifting and really hate tax competition, that they're willing to give tens of billions of dollars of national wealth to us by asking us to tax their multinationals. Should we really take it? What do we do with this money? And so this is the confusion that Pillar 2 has generated. But whatever they were thinking, what you will read in public is that officials from Ireland, Switzerland, Singapore, and Hong Kong ultimately have said, we will absolutely follow global consensus and do our part in international tax cooperation. Okay, that is just code word for you just made an offer that we can't refuse. So this is very real. Economists have estimated how much this ongoing wealth transfer from countries like Canada, where corporate headquarters are located, to low tax countries like Singapore and Hong Kong. The transfer is annually in the hundreds of billions of dollars if you include the United States. Okay. So you might ask, why are these large countries doing this? Do they do this just because some politicians can boast that they have stopped tax competition and reduced profit shifting? Do they do it because someone is taxing their multinationals? They're happy. They take vicarious pleasure in their multinationals being taxed, whoever is taxing them. This seems very warped. Okay. So this is my story. I think it is probably surprising because the normative underlying story seems very hard to comprehend. Okay, I come to the last slide, which is Canada's choice. I make 4 points. First, global implementation of Pillar 2, the global minimum tax, would likely result in large transfers of Canadian national wealth to low tax countries, many of which are not intuitively deserving targets of our generosity. It is hard to think of self-interested or altruistic reasons to commit to such transfers. Now, I want to note that the governments around the world present the pros and cons of adopting Pillar 2 by projecting revenue gains and losses. So in the 2023 federal budget, Canada estimates that it will gain around 2.6 billion of revenue a year starting in 2026. We don't know how this projection is done. Other governments, such as the United States and Germany, have engaged in similar exercises and shown us how actually such estimates might be arrived at. So we hope that Canada is doing the same thing as these other countries. But most of the revenue gain is from reduced multinational profit shifting. And so because tax rates have risen elsewhere, Canadian multinationals may be less tempted to move profit out of Canada. So this does generate revenue gains, but you have to remember the gain comes at a much larger cost, which is taxes are rising elsewhere on multinationals' profits, on Canadian multinationals' income, basically on Canadian national income. Okay, so we're transferring wealth to many other countries just to earn some revenue gain, which is transfer within a country. Okay. So because of the way Pillar 2 is designed, revenue estimates themselves leave out a much bigger issue of national welfare. That's the first point. Second point, if you're in favor of taxing the rich and addressing inequality, we have much better policy choices for doing so. In fact, many of you who have studied tax know that most of Canadian high-income, high-wealth individuals likely hold their wealth through private corporation outside the scope of Pillar 2, and those issues are not addressed by this global minimum tax at all. Third, I have also told you that we shouldn't listen to narratives that because countries have adopted Pillar 2, it's in our national interest to do so. This kind of idea that we have no choice because other countries have done so are confused, and very often, if they're advanced by tax advisors, I would say, you have to think about whether it's self-serving. We should not count on other countries continuing to act in confused and irrational ways. We should also not ignore the great problems of international law that Pillar 2 raises. As a non-superpower, I think Canada benefits from adhering to international law instead of participating in the discourse that says anything goes in international taxation. Okay. And fourth and finally, I think the global minimum tax is a sure win for tax advisors. It's a potential win for rich, low-tax countries. It commits Canada to a meaningless global charade for years to come. Some of you might know that we tax people talk about deadweight loss, a kind of cost that doesn't produce anything. In Pillar 2, we're imposing taxes, not just the taxes may be deadweight loss. We have a kind of meta deadweight loss. Countries go around in fictions, changing little in the real world, then feeding fees to tax advisors and sound bites to politicians. Thank you.